Good afternoon. Good afternoon. It is Thursday. It's September 26th. We are back in court in Idaho for the state of Idaho versus Bryan Kohberger, but we are not back in our old courtroom with Judge. New venue, new judge, who this? We are in court today for a status hearing with Judge Hippler in Ada County in Boise. So this is the court where the case is going to be venued. There are a lot of things still on docket in this case, a lot of unresolved discovery issues. This status conference is very much a pulse check of the case. It probably won't be a significantly substantive hearing, but it's going to be a, where are we? Are we ready to roll? Trial date is set. Do we need to reset a trial date? Can this court accommodate the trial date? Those types of housekeeping materials. Let's get this on calendar. Let's get moving. So court has started right on time. So we are going to roll directly into court and take a look at our, again, new court, who this? So let's roll into Idaho. Again, I don't expect anything of substance. I expect this to be a lot of housekeeping and to then start setting scheduling orders for all of the outstanding motions, of which there are many. There's still a lot of discovery issues in this case, and there's a lot of motion work to happen before this case goes to trial next summer of 2025. So I expect they will cover all of those things, but we might get some insight into what are the big discovery issues still outstanding, if the defense thinks they're going to be ready by summer, and if this court can even accommodate that summer trial date. So it's time. We're going to live court, y'all. We're going to roll the intro. Law nerds, it's good to see you. Let's roll the intro. Let's get to court, shall we? We've got court.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
You guys, I accidentally got myself into full screen in my StreamYard and I couldn't pull up my court feed. I was prepared to be prepared. And then it just wouldn't pull up right. So it's going to take me a minute. I was trying so hard. I moved way too fast and then that became a problem. So it's going to take me 1 second because streaming is dynamic and I fat fingered my own controls because of course we did. Who would we be if streaming wasn't dynamic and things didn't happen? Because of course they did. All right, now we can go to court. I'm going to just cue this up as the hearing started. I love that this court put up a holding screen. That was incredibly helpful. So, new court. Let's see how it goes. Let's roll. We've got a moment here. There we go. Right into court. Let me make sure we've got our volume up as we get there and volume this up. Oh, I'm definitely going to increase that volume. Let's hope for the best. Shall we?
You seated.
Okay, well, I can definitely hear the things landing on the desk. I like the 3-camera view. New judge, new courtroom.
All right. Good afternoon. This is State v. Kohberger. I want to go over the appearances this afternoon on behalf of the state. Would state attorneys please represent themselves for the record?
Thank you, Your Honor. My name is Bill Thompson. I'm the Lake County prosecutor.
Wow, that camera.
Ashley Jennings, she's my senior deputy.
Angle's not.
And then we
my
have
favorite.
Mr. Nye and Ms. Beatty from the Attorney General's office. And then we have victim support staff with us.
All right. Thank you.
Yes, sir.
Defense?
It's interesting that the attorney generals are
Attorney
helping
for Bryan Kohberger,
in this.
Elisa Massa, and Jay Logston, counsel for Mr. Kohberger as well.
Thank you. All right. Like to tell you I'm happy to be here, but why start with an untruth?
What? What? Well, that's one way to start, Your Honor. I would love to say I'm happy to be here, but why start with an untruth? They saddled me with this case, y'all. It's not my choice. I don't really want to be here with y'all. Like, Oh, okay, Your Honor. Damn, he's just like, you guys want to give me a case full of discovery issues with terabytes of data and a 3-month trial? Sweet. That sounds exactly like what I don't want to do. But coming in hot. So so we're gonna back up before I'm shooketh any further because I cannot. I am so blown away by that. So we're just gonna do it again. But all the attorneys are there. I think we've got our volume set and we are ready to go. I saw a couple of you ask, is everything going to be in this court and in this judge from now on, or with this judge from now on? Yes.
For Bryan Kohberger.
Yes. We live here now.
Lisa Massaw and Jay Logston, counsel for
I mean,
Mr.
I do like the
Kohberger.
spice.
Thank you. All right. Like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here. I want to go over with you some
It's giving I'm not even supposed to be here today.
expectations of mine, given that I don't think any of you, other than Ms. Massath, have appeared in front of me before.
Love setting expectations.
When you file memorandums of law, briefs, etc., please provide a Word copy by email to my staff attorney. After today's hearing, you may get that from staff here today.
Okay. Housekeeping. As
Today,
I said.
I know there was an issue that was brought up with respect to Mr. Kohberger's attire for today. I did issue an order yesterday permitting him to appear in civilian clothes for this hearing only.
Oh.
That is a matter in terms of future hearings that we will take up in a closed hearing the day of, but in advance of whatever our next hearing date will be.
Huh.
My intention will be that Mr. Kohberger will not be present for that hearing because part of what we will be discussing are security measures. And I expect to hear from the transport deputies and the bailiffs regarding
Is this a problem?
security issues that they want to address or that I have questions for them about so that I can make an appropriate ruling in terms of his appearance here, but weighing that not just against, of course, his rights, but also against the needs of security in this
Security, yeah.
case.
They seem to have figured it out though, so far.
I do expect, as it probably will come to no surprise to you, for you all to get along. I understand the stakes in this case are as high as they can possibly be in any case, but you are professionals. You have taken oaths, both as of officers
Oh, they're going to get scolded.
within your jurisdictions, but also as attorneys before this bar. So I expect at all times for you to remain civil to one another, that you not engage in personal attacks, ad hominem attacks, that you not engage in theatrics, not mistake the facts or the law to the court, and that when you cite
Don't make me turn this trial
arguments
around.
in your briefs, if there is contradictory precedent, I expect to see that.
Interesting.
I appreciate in advance what should.
He said if there's contradictory, first of all, he scolded them and said, children, you're lawyers, you're professionals, knock this shit off. And if there is any shit, I am going to make you knock it off. He also said, if you are filing motions and there is contradictory precedent, meaning your case law that you're citing stands for this, if there is something that contradicts it, you need to cite both and tell me why the one that you're citing is the one that takes priority or the one that takes precedent, the one I should listen to. Cite both. Don't just leave other shit out so that the motion practice is bitching back and forth of like, well, Your Honor, this case. And then the other side is like, yeah, but this case. No. Tell me what the case is. Tell me what the contradictory, which is best practices. Tell me what the contradictory cases are and let's go forward. He's like, we're going to set the expectations and we're going to behave and we're going to move this shit along. I think this trial might move a little more quickly, or at least the briefings might move more quickly than they had been. He's ready to roll.
Go without saying that I've just said in terms of your responsibilities. But again, I just want to highlight that because I understand when the stakes are high, sometimes victory seems to be the objective when our first objective is to
Do justice.
conform to the oaths that we've taken as members of the bar, as officers of this court. All right. I do have some matters with respect to scheduling that I want to go over today, but before I do that, I'd like to hear from you with respect to the matters that you either need to make me aware of or want to make me aware of. The other thing before I do that, though, I do know that Judge had entered a non-dissemination order. That still remains in place. And unless I, for some reason, remove that order, it will stay in place, and I expect it to be religiously adhered to by all parties, counsel, victims, counsel for the victims. And I will not tolerate violations of that. Likewise, I know that much of the evidence in this case has been subject to orders sealing under that dissemination order or otherwise have been sealed by the court. I likewise expect everyone that has access to that information, whether it's sealed documents or information in sealed hearings or the information itself in the documents, to adhere to the confidentiality expected as it relates to those. Okay.
Okay.
That's my one and only lecture for you for the remainder of this case.
That was 2
With
lectures.
that, let me hear from you. We'll start with counsel for the state.
Your Honor, I don't know that we have specific questions we want to propose today. We're looking forward to hearing the scheduling. I think that's going to drive, for us, particularly the distance involved, any questions that we may have. I appreciate what you've already mentioned to us, and we will certainly honor all of that.
Santa, can you sit down? We can't see you.
Taylor?
Thank you, Your Honor. There are a few issues that I wanted to make the court aware of as the court decides on the scheduling order. We want the court to know that our team has been working towards the June of 2025
There it
trial
is.
date that had been issued by Judge Judd.
Hi, Your Honor. Happy to be here. Nice to meet you. Yeah, that trial date's way too soon. That trial date's way too soon.
In the case. But in candor to the court, I need to let the court know
Yeah,
some
it's not happening.
issues that have come up that we face that causes me concern.
Yeah.
First,
There it is.
I think the court's probably aware of the vast amount of discovery that's been exchanged in the case by reviewing the record. But since August, we have received about 398 gigabytes of new information. And I
That
can
is a
tell the
lot.
court that nobody on the team has read every bit of that yet. So there's a vast amount of discovery to continue to go through, and I wanted the court to be aware of that. The second thing is that during the course of this case, we had an expert that we were working with, and that expert passed away. We have been able
Oh.
to refill that role to have
That's-
a new expert
that's
to
a
do
challenge.
the work that expert was hired to do, but we are not progressed to the point that I'd hoped to be through no fault of the new expert.
Yeah,
The
that's
court should
not
be aware of that as well.
on
And
them.
last, as the
That's
court is
unfortunate.
very well aware, the system of delivering public defense is changing next week. As appointed counsel in the case,
Oh.
I do not have a contract yet.
Oh.
Nobody on my team is under contract for this case. I'm concerned about what that means, and I thought the
Oh.
court should be aware. Further, we have been able to access funding to help us prepare this case through Idaho Criminal Rule 12.2. At the current time, we're working with about 25 experts and investigators to prepare the case. I don't know if
Wait, how many did she say?
12.2. At the current time, we're working with about 25 experts and investigators to prepare the case. I don't know if 12.2 will continue to be the way to get funding for those experts and investigators, or if that's changing. And I thought the court should know those things. Thank you.
Those are some substantial issues. I'm going to pause real quick. 3 things that Ann Taylor said in quick succession, 4 things she said in quick succession that are impactful. 1, They received over 398 new gigabytes of discovery. Their whole team hasn't gone through it. 2, the system of public defense is changing, meaning the state is changing the way they are providing public defenders, contracting with public defenders. This happens, but none of them have a contract, which means the transitioning and how public defense is going to go forward is still unclear. So they may not be the lawyers on the case going forward if the contracts do not get negotiated. So there may be financial issues for these attorneys. None of these lawyers have contracts yet with the public defender's office, and so may not be able to continue because they are covering a Latah County case. They are not Latah County defense attorneys. So there's a lot of intergovernmental workings here that might create an issue. And if they need new defense attorneys, it's going to push the trial back a year plus. But we'll see. The contract issue may be a big issue, may not be a big issue, but it's unknown. And Taylor raised the issue saying this might be an issue. Third issue, they were working with an expert who passed away. The new expert is not as progressed as they would like the new expert to be, meaning the new expert that they are working with needed to start over from zero. And that is moving slowly because all the work has to be redone, which is a problem. Also, because the government funding is an issue, the fact that they have over 25 experts and the code section that allows for that funding, the funding may be changing. And that's what she was talking about, 12.2. If that funding changes, they might hit further roadblocks with their experts and have other issues with how to bring in their experts. These are not insubstantial issues. These are potential problems, potentially large problems. But I saw a number of questions. Is this a defense tactic? No, some of this is the function of your government dollars at work. When things shift, they shift. There are only so many hours in a day. There are only so many lawyers, and there is a lot of discovery. This is also a DP case. This is a death penalty case. The obligations of the defense attorneys are very high here. And at the end of the day, no matter what the judge wants to do, if the defense attorneys say, we are not ready, we do not have the experts we need, we do not have the funding we need, and we cannot move forward yet, there's not much the judge can do to force them forward. So at the end of the day, if they put their foot down and say, no, we can't go to trial yet, there's nothing the court can do except say, you're right. That shifts if the case didn't have 2 parts, but let's finish this hearing. Though, Ann Taylor's like, hi, here's a lot of very substantial problems. Just thought you should know. Wow.
Thank you.
Wow.
So I am hopeful that Mr. Frederickson will ensure that the contract is available for you and your team next week. I have no control over that, of course.
Nope. Separation.
Other than to, as it relates to who I permit to withdraw from this case or not withdraw from this case.
Your Honor. I have no control except for who I permit to withdraw or don't permit to withdraw. Your Honor, if they're not getting paid, you can't force them to stay on. Wow.
As to 12.2 funding, my understanding is, and I've had a discussion with Judge Munson, who has been serving, as I understand it, as what we refer to as the money judge. I've asked him to remain in that capacity at least through the transition to the state public defense system in next week on October 1. My understanding is, and perhaps I will come to find out something different, but that once it goes to that system 12.2 as it relates to public defense funded attorneys on contract seeking 12.2 funding, that's no longer a thing. That would come through the state public defense budget, essentially.
They've moved the budget.
I guess we'll find out if that becomes a problem down the road, but that's my understanding.
Sounds like it's going to be
a system that 12.2 is based upon is coming to an end. So, given your statement about the trial date, my proposal to move this case forward into May is probably not going to land well with you, but that's what I wanted to talk about, is the timing of the trial.
Ann Taylor, Your Honor, hey, I know you're happy to be here or not. Here's a literally tow truck of shit that we have to deal with, and the money is changing. And the judge goes, I would like this trial to start in May of 2025. He's like, so can we just make this trial go faster? And Ann Taylor's already like, yeah, we're not gonna meet that. This is not going to be well taken. Wow.
I'm concerned with a trial as currently set for a number of reasons. But first, I want to find out from you, as you sit here today, what that trial looks like in terms of the number of
They
weeks
said
of
3
trial,
months.
starting from after a jury is selected through the end of the evidence and before any potential
Penalty phase.
sentencing phase.
Mm-hmm.
So
Prosecution? How many witnesses?
what are your estimates of that?
How long is it going to take?
Your Honor, I think it would be a fair estimate based on what we know at this point to have a month and a half or perhaps a bit more just for the evidence for the guilt phase of the trial. I say that knowing.
Is that just your evidence, or does that include defense evidence?
Well, I was just getting ready to say,
His.
I say that understanding or
His.
acknowledging that Ms. Taylor has estimated 2 to 3 months total. I do not know. We do not know what the defense has in mind for their case right now. So all I can speak to is what we anticipate.
He's saying a month and a half to
But I
2
would
months
think
for their
the
case in
state's
chief.
Evidence in chief should be able to come in a month and a half or so.
Okay. Ms. Taylor?
Your Honor, we estimate 4 weeks for the defense portion
Wow.
of the trial case.
Of the guilt phase?
Yes, Your Honor.
I'm surprised she didn't say of the innocence phase, because that's what she says all the time. 4 weeks.
10 weeks.
Of the defense case.
In terms of if there is a penalty phase, should the defendant be convicted of one of the statutory qualifying offenses, how long do we estimate the penalty phase being?
Your Honor, from the state's perspective, I believe we're going to be relying heavily on the evidence that's introduced during the guilt phase, and the additional evidence that would be brought in, unless there's something we learned from the defense about their experts, it is probably take no more than a week.
Taylor?
Your Honor, I would estimate
Really
2 weeks for that part of any trial.
So 3 weeks total.
For our evidence.
For your evidence.
Yes.
This is the penalty phase. So on a death penalty case, the jury will determine if somebody doesn't plead to the guilt phase or the factual phase of the case. You will do the trial with the case in chief first. If there is a conviction, then there will be a penalty phase. If there's not, there won't be. And then the penalty phase will decide if it's life or death, literally. So that's what they're talking about. The defense generally puts on a longer case at that, at the penalty phase. They bring in a lot of witnesses for things to be considered in mitigation is what they want. So the prosecution is saying a month and a half to 2 months. So 6 to 8 weeks. The defense is saying 4 weeks. The judge is saying 10 to 12 weeks. That's what we've been hearing the entire time for the case in chief, 10 to 12 weeks. Then we get another 3 weeks for the penalty phase. So we're looking at 15 to 16 weeks of trial if everything goes well. And that's not including the jury selection, which realistically could take 2 to 3 weeks in this case. So that's going to be, 3 to 4 months. And then those estimates can change if new experts come in or what have you, but
So my concern, because this trial is currently set to begin June 2nd and end approximately August 31st, is having it set to run the entire course of the summer. I think we will find it to be difficult
for the jurors.
on jurors,
Yep.
in particular, jurors who may have children who are out of school, in terms of
me.
being able to spend time, go on vacations with them, et cetera. That's one concern. The second concern is with school that typically starts in mid to late August.
Thanks, Your Honor.
Jurors or parents who may have kids going off to school, the timing of that through August. That's
Sucks.
my primary concern.
Part of the reason they picked summer is because of how impactful the university is on the Latah County area. The choice of summer was trying to pick this when the university was out, when it would be easier to accommodate transportation because it's a smaller county. The judge is like, look, it's Boise. We don't have the same issues, but if you try this case over the entirety of the summer, jurors are going to come in and be like, yeah, I can't do that at all. Like, there's not a chance I can do that.
Concerned about that time frame. I had two proposals. One was to start the trial in the evidence portion of the trial the first week of May.
Oh, so start jury
And the
selection in
other would
April.
be to start the evidence in early September.
He wants to push it to the school year.
Like your thoughts on those?
It's going to get pushed till September.
I'm not saying I'm have or necessarily will vacate the June trial date, but I want to look at alternatives here because I am concerned about that
Yeah, it's going to get pushed.
spread that takes the entirety of the summer.
Me too, Your Honor.
And we hear you, Your Honor.
All
By
these
way
high
of history, the summer
all these high profile cases happen in the summer. The law nerds haven't had a real summer in years at this point. So we hear you, Your Honor. And, Corey Richens is going to trial in May. So if we could just not do this in June, going back to the fall is not the worst of the options.
we advocated for that in Latah County because the courthouse is right across from the high school, and the summer would have the students gone. If we were looking at the other two choices, we would propose May.
Taylor?
Thank you, Your Honor. Your Honor, I would have to advocate for September at this point, based on the three reasons that I gave the court before.
Yeah, and that's why. September is
So,
what they want.
I'm not going to worry about the public defense change because I think that
We'll resolve.
will take care of itself. The one thing that you brought up the most, I mean, I understand there's a lot of evidence, but May is not tomorrow. May is many months away.
May feels like tomorrow.
So the one that concerns me that you brought up is your expert. And I'm not asking you necessarily to give away any secrets prematurely that you may have in terms of defense strategy, but can you help me understand this expert if you're able to, and what their role is and what the prospects are?
Your Honor, it's really difficult to tell you much about the expert without giving away a lot. I can tell you that this is a very necessary expert for us to have on board. We've been able to find somebody to fill the role. I'm confident in the person that will fill the role. There just hasn't been enough time to get the work accomplished yet. I know that that doesn't tell the court a whole lot more than what I said before, but I really feel that that would disclose too much for me to say more. I could do so.
She's like, I would like to say
on
less.
an ex parte basis or with Judge Monson, our resource judge, but not in a public setting.
I understand.
That's
Do you
fair.
anticipate fulfill your obligations for your current expert disclosure deadline that was set by Judge?
Did you see Anne's face? She was like,
Um,
so about that.
No, not with a lot of confidence. I think that the work is going to take longer than to meet that deadline. I think if we met that deadline, I would have additional information that I would want to be able to present. And maybe I would have been stopped from that with that deadline.
Yeah, they're going to need an entire new scheduling order, it sounds like. Well, maybe we won't be here all summer.
So I don't have a motion to extend that date, obviously, and with the changes that occurred, I understand why you didn't file one out of the box, but the deadline, I think, is January 6th, something like that, if I'm not mistaken, for experts on the defense side.
That's one of our deadlines, Your Honor, yes.
I guess the state have anything to say in response?
Not knowing the details of the challenges Ms. Taylor and her team are facing, I don't really know how to respond further. Your Honor.
It's like there's nothing we can add.
What do you think is a realistic deadline for you to be able to disclose your experts for everything? I'm assuming it was January, all save that one expert. But with respect to the expert you had to replace, when do you think you could disclose consistent with
I don't think that
the
expert,
scheduling order?
here's the sense I'm getting, that expert, they've retained a new expert, but their work's not well underway. So they don't know. They can't really answer because we don't know what kind of expert it is. The defense can have a lot of different experts. So they don't really know. The defense doesn't really know how to answer, but it seems like with an expert that passed away, they are trying to figure out when they can disclose that expert. But I think they've found a new expert, but that expert's not even underway yet. So it seems that it's hard for them to estimate when that expert will be ready because that expert's not really into their work yet. That's the sense I'm getting.
Other than the expert that had to be replaced, Your Honor, there were two separate deadlines. One was for trial experts and one was for mitigation experts. And I believe that I can make that deadline other than that one expert.
Well, that
Can
makes
you tell
sense.
me if the one expert is a mitigation or a trial expert?
A mitigation expert, Your Honor.
Oh, well, that makes sense. So when they say mitigation expert, what they mean is that is an expert that will go to the penalty phase if there is a penalty phase. So the mitigation expert, depending on what they're working on, can be working on things like his entire life story and what have you. So with the expert that was working that passed away, that is an expert that will be disclosed at a later deadline than the January deadline. Those are the trial experts. The mitigation experts get disclosed later.
And what do you think you need for that mitigation expert in terms of a deadline? Compared to that mitigation deadline was,
I believe it was March. I don't recall the exact date.
yeah, so that's a long time from now. So
Yeah.
um,
Do your best.
I have a lot of questions, but I'm hesitant to ask you the questions because I'm sure you're not in a position to answer them currently.
Yeah. Do your best
given
and
the
file a motion later if you need to.
forum.
March is a
So-
long time.
But March is a long time from now.
Yeah.
Your Honor, the time passes very rapidly, and I appreciate the court asking questions I can't answer. I think if I had an end of April deadline for that one witness, I think we could make that deadline.
Why don't you work on it and let the court know in January or February? Like, why don't you wait till you're closer? Maybe she knows, but I would think, Your Honor, we're letting you and the state know now. Can we let you know in February if we're not going to make the deadline? We will try. But can you please keep an open mind that maybe with this expert, we'll need to push it and we'll get everything else to you. That's at least a little bit of a compromise there. So
understanding this is a mitigation expert, Thompson, how concerned are you about getting that disclosure closer to trial?
Closer to trial is somewhat relative. The end of April sounds like it would be on the eve of trial from the date the court is proposing. I think that would be, I'm not sure that would be realistic.
This isn't happening
And
in
again,
May, Bill.
I'm not in a position to second guess
Sure.
what Ms. Taylor and her team are representing to the court. She had told us some time back that one of her experts had some health issues, and I think that she did tell us that that person had passed away and they were working on a replacement. If we're looking at a mitigation disclosure at the end of April, I don't know that we could be ready with all the final trial preparation for a May trial. I hate to say that. I feel like I'm cutting my own throat in a sense, but that's realistic.
Did he just say I feel like I'm cutting my own throat in a sense? Bill, sir, we need better analogies.
Well, I can do one of two things. I can set a separate hearing ex parte to explore this further, but I frankly don't know how far that's going to get me. I mean,
he's not going to acquiesce at all. The judge is not going to acquiesce at all. He's like, no, I want to know more. This judge is like, nah, we need to not be here for another 3 years.
I can set a date, and my experience tells me that date will be complied with regardless, right? 24
That's
hours
true.
a day, but if you use enough of those hours, enough days in a row, you get it done if you have to. At the same time, I don't want to
create appellate issues,
unrealistic deadlines. And so I can do that. I can have an ex parte hearing, or we can go ahead and reserve September. I will throw it to you, Mr. Thompson, is what you want, what you would advocate for.
Could I have just a moment?
People aren't going to be happy with it getting pushed till September, but it's better to, the difference between May and September.
Your Honor, we trust the court to do the ex parte hearing, see what's there and make the best decision and tell us what the expectations are.
Yeah. It's going to end up in September is what's going to happen.
Well,
you can't push the defense
later today, or you want to do it tomorrow? You need more time? You want to come back next week?
Y'all already drove here.
Your Honor, I had planned to leave town today. I have other case-related obligations tomorrow. I could do it as soon as this hearing is over if the court has time, or I can come back next week at the court's convenience. I think we'll probably be finished in here by 3 if we were to do it immediately after. Are you comfortable with that? Does that give you enough time to get to the airport?
Yes, I believe it will, Your Honor.
All right. Well, we'll
He's like, all right,
give that a shot.
Let's do it now.
All right.
I think we're done here.
Well, if I move this one way or the other, I will adjust the various deadlines that are in here. I won't adjust the next deadline that you have, understanding that you may be already committed to it, which I think is the motions related to the defense's motion regarding the death penalty, if I'm not mistaken. Is that the next set of hearings that we have?
Those are now scheduled.
I believe that our briefs are due the 10th of next month with the hearing later this fall and a reply brief deadline for the defense. And we are on track to meet those deadlines, Your Honor.
I'm sorry, you were saying, counsel.
Your Honor, I'm guessing the court has received our motions already. I believe we were set for November the 7th.
I think the state's deadline for discovery has passed. Has the state complied with its discovery obligations, including those outlined in judge's last order and other orders?
We have, Your Honor, and in fact, Ms. Jennings prepared a lengthy summary of all the discovery that was filed with the Latah County Court when our discovery deadline hit. It is lengthy, but there's a lot of discovery.
Sure.
We recognize that.
How much of the, would you say 300 gigabytes?
That's the new shit.
398 since August 13th.
How much of that is new information?
Ms. Jennings could speak to that.
This judge is like, I want you to
Ms.
tell me
Jennings, Can you
everything.
speak to that?
We're not just pushing things.
Your Honor,
She's
the
like,
defense
"Fuck,
was
no."
given, and I'm not sure if this is what they're referencing, but they were given.
She's like, damn it, I was not prepared for this today. The judge is like, is this new? Is this duplicative? Is this the, partner officer's body cam when we have the other officer's body cam? Is this new? This judge is not holding back on, you're going to tell me why you need more time. We're getting this moving. He's definitely not going to fuck around with this case.
A copy of the OneDrive from the FBI. Most of that was cumulative discovery that they had already received in another fashion. I'm sure there were portions of it that was new information. I've not calculated how much of that was new. So I can only rely on Ms. Taylor's, what she's represented to the court on that.
It doesn't matter for the defense, though, if it's new, they still have to go through it. They have to go through all of it. Whether it's new or not new, they have to go through it. Because if there's a video that in the first 3 minutes looks like the same video, but then the last 10 minutes are additional from other videos, you still need to know. So they still have to go through all of it.
Well, I don't think she knows because it doesn't sound like she's looked at it yet.
All of it, Judge.
Right.
All right. Well, I will talk when we're finished here with Ms. Taylor without the state present in a closed hearing. What else do we need to talk about today, or do you want to talk about today?
The state's like, not much. We good. We turned over our discovery.
Nothing comes to mind right now,
Peace.
Judge. I know that there will be plenty of opportunity for other discussions. As far as your meeting with defense ex parte, do you want the state for any reason to stay around, or would you like us to get on the road back to Moscow?
Are you flying or driving?
Driving.
Okay. Well, why don't you hang around just in case we need to
Put a new trial
if I'm
date on the
able to make a
record.
decision based on that, I can inform you what that is at least.
Yes, sir.
Yeah.
Thank you.
Anything further other than your motions regarding the death penalty? Do you have any outstanding motions and the motion as it relates to Mr. Kohberger's attire?
Your Honor, there's no outstanding motions right now. I do anticipate filing several motions in the motion to compel deadline. As far as discovery goes, I anticipate there may be some follow-up motions. I, of course, will first try to speak with the prosecutor to resolve those.
Right. I think you will find I'm probably more inclined to hear things more quickly than you're perhaps accustomed to in this case. So just be aware of that. It'd probably be more along the usual.
Not the judge shade. We're going to be moving more quickly than maybe you're used to. There's literally a new judge on the bench. We know it is Judge. We are not the judge. We don't need to be named twice, but we're going to move, and y'all are gonna get this done like adults. Just so we're clear. He's literally like new sheriff in town. Oh, judge, he's not messing with them. And he's like, okay, you need to explain to us why you need more time. We'll do it in the next party hearing. We'll do it today. Explain to me what's going on with this expert.
Right. I think you will find I'm probably more inclined to hear things more quickly than you're perhaps accustomed to in this case. So just be aware of that. It'd probably be more along the usual, 14-day timeline with respect to motions. If there's a lot that needs to be done with respect to them, we can talk about that.
Let's move.
Okay.
On that point, Your Honor, as you can see, they're a multifaceted team. And on motions, we try to assign them to specific attorneys. On various motions, would it be acceptable to the court for those attorneys who are not actively arguing the motions to be able to participate remotely Or would you like us to be present? We're happy to do either.
I'm fine with that. I just prefer those that are going to be arguing to be here, just because it makes it easier to have that dialogue. So
Okay, thank you.
the others, if they want to appear remotely, that's fine.
Thank you.
And same for defense as well, depending on what defense wants to do. Okay. All right. Then if there's nothing else this morning or this afternoon, I guess we will be adjourned and have a discussion in a few minutes. All right.
And there it is.
Back in a few minutes once the courtroom is cleared.
He's like, everybody out. We're doing a closed hearing. And just like that, the judge has said, I'm not happy to be here, and we are going to do things more quickly than maybe you are used to. So the new judge in the Idaho case is going to move things along, but is also mindful, very mindful, of the fact that the defense has quite a lot on their plate. Let's do a summary of this status hearing, and I'm going to get briefly into your questions, but we have already streamed today, so am I going to get into that a lot? No, we got a lot to do. So let's do a quick summary and answer some of the questions y'all have. So our first status hearing in the state of Idaho versus Bryan Kohberger for the quadruple homicide out of Latah County. It was moved subject to a motion to change venue to Ada County, where Boise, Idaho is a much larger county, different court system, and a new judge who came into court and said, not only is there a new judge, but literally there's a new sheriff in town, and it's me. He came in at the very beginning of this hearing and said, I would say I'm happy to be here, but I'm not going to start the hearing with untruths. So he has set the groundwork for, this got assigned to me. I'm not even supposed to be here today, but we are going to move this case along. He then proceeded to remind the attorneys that they are not only adults, but they are adult professionals. There will be no personal attacks, no ad hominem attacks. They will do their work like professionals. The mood of the courtroom was incredibly subdued today as Judge Hippler moved through everything that was on the docket, including the fact that this case is set for 3 months when you're looking at the case in chief of the state, the case in chief of the defense, and then the potential for a penalty phase for the death penalty versus life without parole. The prosecution said that it was going to take them a month and a half to 2 months for their case in chief. The defense indicated that their case in chief should take about 4 weeks. The prosecution said if this goes to a penalty phase, it should take about a week of their witnesses, and they're going to rely heavily on the trial witnesses in the guilt phase. And then the defense said that they are going to take about 3 weeks in their rebuttal. The defense then laid out the fact that there are issues for them. They had an expert that was ill and then passed away who was already well underway into their work, and replacing that expert is going to be difficult and time consuming. The court is doing a hearing closed with the defense ex parte without the prosecution to talk about that expert, and if the expert disclosures need to be pushed back, and if the trial date needs to be moved to September 2025 to not only accommodate the fact that jurors are going to be disinclined to be in trial for the entirety of the summer, and to give a little bit of room to the defense when they have been kind of kicking since the beginning, saying, we're not going to be ready for this trial date. We're not going to be ready for this trial date. The prosecution was pushing for March 2025. The judge resolved June 2025, and the defense is still saying, we just need more time than that. We have a tremendous amount of evidence. We don't have a contract because they're changing the public defender system in Idaho, and our expert passed away, and we do have a new expert, but we need more time. And we have to work together to figure this out. The court said, I am inclined to have this trial start in the case in chief, the evidence portion of the trial, not jury selection, which may take 3 or 4 weeks, but not jury selection, the evidence, opening statements forward, to start either in May or September. The prosecution's asking for May. The defense is asking for September. I think at the end of the day, we will probably see it happening in September, given all of the things that the defense lined out and given the fact that they do have a substantial obligation in this case because of the penalty involved and because of the amount of evidence. This is terabytes and terabytes and terabytes of evidence. At the end of evidence disclosures from the prosecution, there were 398 new gigs of data. The court asked the prosecutor, well, how much of it's new? How much of it's cumulative? And the prosecution's like, so it's a OneDrive from the FBI, and we don't know how much of it's new and how much of it's cumulative. Sorry, it's a lot of evidence. I think we'll see the judge move this to September. I think that's realistically what's going to happen. So with the change of venue and with the new judge, we are now moving forward. So Judge Stephen Hippler, we are in your court, sir, and we have heard you that this case will be moving faster than the attorneys were ready for. So it seems that a trial date change is imminent. Now that the defense got their change of venue, will they get the trial date that they want? I think it's possible. So with all of that, let's get into a few of your questions, shall we? It's time for Q&As. All right, y'all. I'm going to go through some of the super chats. It is our second stream for today, so it's going to be a quick one, but we are still going to go through it. Let me send out a link real quick because I need to send out a link real quick. Give me 1 second. So that is what I'm doing, but we are going to go through questions quickly. I saw a lot of you ask why the new judge. Well, because of the change of venue. The defense asked for a change of venue. Judge granted the motion. The case moved to a new county. And when it moved to a new county, it got a new judge. So that is why the new judge, who is maybe not thrilled to be there. Some of you were asking about the ex parte and how it is okay. So Paula, I've seen a lot of you ask that. How is the ex parte with the judge and without the state allowed? I thought we learned through YSL trial that both parties must be present in ex parte meetings. Ex parte means ex parte. It means without one of the parties. Ex partes are a normal and permissible part of trial, depending on what is discussed. Discussing the ins and outs of what a defense witness may say and the fact that a defense expert and what that expert goes to prior to defense expert disclosures is a perfectly appropriate thing for an ex parte. If a defense attorney and a defendant are having issues and the defense attorney may need to withdraw, that's something that can happen with the defendant, the defense attorney, and the judge. But when you are talking about a witness making statements who's about to take the stand, like in YSL, that is a completely different matter. However, there are things that happen ex parte or in camera with the judge all the time, reviewing witnesses statements that may be sealed at some point. There are lots of ways ex partes can happen. Ex partes are not bad. The way it happened in the YSL case, I still think was inappropriate. The courts there disagree with me. I'm not a judge in Georgia, so they are right. And my thoughts on it are kind of irrelevant. So again, ex partes are not inherently a problem, but they mean one party only. If an attorney has a timing issue or a family issue, they can go to the judge without the other lawyer there and say, this is what's going on. So lots of things can happen. The way it went down in the YSL case is what the problem was. So hopefully that helps, law nerds. That was a great question because I'm sure there was some confusion. Okay. I'm responding to a text because there are a lot of things going on here today. All right. So let me continue on with our questions, but that was a great question. Let's see. Daisy and Rue's mom said, excited to join for a bit while on vacay in France. You guys are having the best vacays ever. Look, I'm not going to be mad if this moves to the fall. I'm really, on a personal note, just not going to be mad. Aaron said, Is Alex Spiro serving as Eric Adams' attorney? I have heard that. I have not looked at the news today to see if that's true or not, but that is what I have heard. He's a New York attorney. He's a criminal defense attorney. Things are possible. Roxy said EDB streams are making me feel less alone as I go through another loss. I'm sorry. We are here. The Lawnards are here. And that is what community is for. So you can take a minute to be with the Lawnards while you're going through it, or while you're studying, or while you're cleaning your house, or while you're obsessively watching hurricane coverage and listening to me prattle on about court, whatever it is. Wolf Kiara asked, how are clothes a security matter? It's not the clothes per se that are the security matter. It could be the facilitating changing of the clothes. It could be the types of restraints he's in, but this is unusual. A lot of defendants for pretrial hearings come in their typical jail clothes. Not all defendants come in street clothes in their pretrial hearings. It is not always permitted by the court. This court wants to evaluate that. I wonder also if the judge is like, we're not wasting the sheriff's department's time on this. How many sheriffs does it take to change him in and out of clothes? Is this an issue? Does this slow us down? We're going to reevaluate everything fresh. This judge is reevaluating everything fresh. He's like, we're not messing around. So it is not, I mean, it's not unusual. It's more unusual that defendants are in street clothes for pretrial hearings and stuff than not. Casey Cat said, Judge Dad, don't look at or touch each other. Share all comic books. Keep hands inside the windows. Don't wait until the last minute to say you need to pee. Don't make me turn this around. Then the stern dad look. He definitely was lawyers. May I remind you that you're lawyers. Thanks. What we're not going to do is grandstand and theatrics. We're not going to theatrics. Lyndon in the chat said, Your Honor, I know that you're not happy to be here. Here are more problems. Yep. I've never seen a judge straight up be like, I don't want to do this. Like, I don't want to be here. I got volunteered. Like, I got volunteered. They were just like, it's you, buddy. He didn't make a joke about who he pissed off. But he definitely felt volunteered and did not like it. Happy at Heart said, why is the defense demeanor softer with this judge? The nature of the hearing, I think, is where you're going to see a shift in demeanor. The nature of this hearing is very much we need to get some things straight and we need to figure out where we are. This was a status hearing. Literally, what is the status? Where are we all at? You good? You good? What do you need? What problems do you see? What challenges do we have coming up? Tell me where we're at. It is truly a temperature check. And that's what the judge did. Are we going to meet our deadlines? Are we on track for trial? Can we go faster? Do we have to go slower? That's all. So the tone is different because Ann Taylor's not fighting for or against anything. It is literally just this is where we're at. So Denise said, I just left the courtroom. I love this judge. Denise, he was very no nonsense. And that's kind of what a case of this size needs. Judge loved to have a chitty chat. He was like, ooh, I'm fascinated. Tell me more. This judge is like, we're not going to be here forever. This case needs to get done. There are other cases that need to get done. This is not our moment. We're not having a moment. What we're doing is moving this case through like every other case gets moved through. So that is. Judge's intro was like Snape's potions class intro. Yeah, could you see him coming in the black robe, just like closing all of the windows? I see it in my head. Well, I see the meme that I want to see in my head. Snape walking in with the robes. That is it. So we are going to get wrapped. AJ Charles says we'll all feel married by the end. It's going to be months of trial. I mean, we've done 7-8 weeks of trial. 3 months of trial is going to be a lot. Like, it's going to be a lot. It's going to be a lot. Spock's Brainworm says, I already miss Judge. So Casey Cat said, but Your Honor, DA Santa is very, very busy at the end of the year. I mean, that's fair. DA Santa can be very busy at the end of the year. This is Mujer Barbacoa said, Judge, no faffing about. Correct. No faffing at all. Middle of the Sky said, so far I like this judge. I like this judge too. We'll see. Beth said, I wonder if DC is regretting their change of venue request. This judge has zero tolerance for shenanigans. I like it. I like zero tolerance for shenanigans. There shouldn't be shenanigans. It should just move smoothly. Molly said we call it voluntold. Yes, it's exactly what it is. Volunteered, voluntold. Yes, you were assigned. No asking. Cloak, the librarian, said guess we're spending Thanksgiving in Idaho. Maybe will, maybe not. Buffy said I'm asking for September if anyone cares. I very much care. I also am asking for September. Look, it generally gets me clear of concert schedules. My kiddo will have a lot going on next summer, so it would be nice. Then it'll be cute. We'll do the Corey Richards trial in May, and then we'll just kind of keep up with what's going on, and then we'll like reconvene in live court in September. We'll just get into it in the fall, and then we'll have a little bit of a summer. So I think we'll probably end up in September. I know it's frustrating, but based on what Ann Taylor said today, even if the judge tried to set it in May, it's going to get pushed back. So might as well just set the expectation now. And I can see this judge telling Ann Taylor, I am hearing you. We are setting it for September 2025, and I am not amenable to reconsidering that at all. September. And that is it. That is what we're doing. So I could see him giving Ann Taylor the date she's advocating for with a very firm floor on, and it's not moving. Like it is not moving. Then again, other judges have said this case is not moving, and they move. Trials move. Trials move the day of trial. It's really annoying. It's like my hair is done. I'm in my jury selection suit. I'm all dressed up and ready to go. And then it's like, Your Honor, we need to move the case. It's like everyone is subpoenaed. Moving it now is better than moving it 6 months from now. And I think that's what's going to happen. Law Nerds, I will keep you posted in the app if this judge comes back with that today. It'll probably be tomorrow if he updates it on the public website. So I think we'll see it. I think we'll see it on the public website tomorrow if he picks the date. He's not going to push back the November hearings. There probably won't be much happening in this case between now and November, and then we're going to start getting into those hearings. So we will be back in Idaho in a while. We'll be back in Boise in a little bit, but we're going to be dealing with some other cases before that. So CW, I saw in the chat, you said you haven't gotten an app notification in 3 weeks. Look at your settings, especially if you updated your device. Take a look at your settings and try toggling them. If not, help at emilydbaker.com. We'll get back to you. Team Baker is off tomorrow, but we will get back to you next week. But try taking a look at your settings. That generally is what it is, that settings have gotten shifted, and we will go from there. So with all of it, thank you for joining me in court twice today. It was double the ride of court, but y'all, it's time to have a good weekend. I am hoping that the weather holds out. Fingers crossed. Law Nerds, I will keep you updated in the member spaces. I will also try to keep you updated on the weekend shenanigans on Instagram. I am very excited to go to DMB this weekend. I am ready for a little bit of a break. I got to be honest. It has been very busy work-wise. I am ready for a little bit of a not as busy. So, Law Nerds, I will see you soon. Members, I will be keeping you in the loop with all of the weekend things. My weekend is starting soon because, we're taking Friday off as much as we can. I'm going to have to record some stuff, but we're taking Friday off as much as we can. We're going to go do the Dave things. We're going to do the homecoming weekend things. RK, yes, exactly that. We're going to do the homecoming weekend things and just, take a minute to take a minute. I hope you all have an opportunity to do the same. And with that, Law Nerds, it was great seeing you. Thank you for being here. Thank you always for being a Law Nerd. Thank you for bringing me along on all the things you're doing in your day or your evening. And with that, we are out from Idaho, and the new judge is his own vibe, isn't he? So let's get rolling. I'll talk to you soon. Bye, guys. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time
for the quick bits. Thanks for being a law nerd.